Who logged me out now? Hello?
Hello, sir. The host ended the meeting, sir.
Host ended the meeting?
Yes, I think maybe it was a mistake.
I don't understand though. Okay, no problem. I don't even know where I stopped before the meeting. Where did I stop? I've been speaking and speaking.
Sir, you were talking about your own view on when it comes to conflict of law. That one is amenability to a particular law.
Okay.
Transaction.
That the three questions that legal pluralism chooses. That's what
Yes, I said that legal pluralism, you will find any of three questions arising. Okay? Because people are giving choice as regard which of two or more competing personal systems of law on a subject they can use to do their transaction. So you have three questions. The first one, the two or more personal systems. What is the formula for determining who is amenable to what? The second question is the test for change, for recognizing change. Somebody who is amenable to personal system A before, can he ever become amenable to another personal system? And what formula do we recognize for him to be so amenable? Okay, and the third one is when persons subject to different personal systems of law interact. So this one is the equivalent of the private international law issue. So that in private international law, we are talking about marriage between Nigerian domiciliary or national and Portuguese domiciliary or national. In internal conflict, we are talking about marriage between people who are amenable either to Islamic law or to one particular system of ethnic customary law, and another person who is amenable to another ethnic customary law or customary law as the case may be. We may also be concerned with the question of double-decker. The question of double-decker. Two persons who married under their ethnic customary law, Islamic law, then finding that not sufficient, decide to go to the registry. That's what we call double-decker. So all of these issues are issues of internal conflict because there is nothing that links the matter with the law of another country. But within Nigeria, there are two or more personal systems operating, and the court will have to determine which of them will govern the issue. Okay? So that is that with the dimension. We will now move to private international law. When we talk about marriage in private international law, we are invariably, like I've said, concerned with marriage involving, having connection with another legal district. How can a marriage have connection with another legal district? Two possibilities. Either one of the spouse is domicile or a national or whatever of another country. Two, the couple might both be domicile in Nigeria, but if they celebrate the marriage outside of Nigeria, you cannot ignore the law of the place where they celebrated the marriage when issues relating to the marriage arise. Okay? So those are the reasons why we might say marriage has a foreign element. You can see that in Fonseca and Passman, it really has a foreign element because the husband we were talking about was a Portuguese. And that was the only account upon which the court decided to nullify the marriage, because the court said foreigners have no capacity to enter into customary law marriages. Whether they were right or not, we will, when we get to the place where we will see what is the English law position on the issue, we will look at it. Okay? So, if you go to, we want to be practical. We want to be practical. Let us say, you see, we are told, if you read textbooks, they will tell you that conflict of laws will usually spring up when you are least prepared for it. You want to file a petition for nullity or for divorce before Nigerian court, you probably would use the same procedure that anyone would use in Nigeria, okay? But the moment any of these facts I have mentioned as making the matter to have foreign element is disclosed, the judge is bound to recognize that you have thrown up a conflict of law issue, okay? So you filed a petition, say for nullity. You want to dissolve a marriage. And in your petition, you show that the marriage you are talking about was formalized in, say, Ghana, Kumasi in Ghana. Okay? Depending on the ground that you want to nullify the marriage, the judge has already been put on notice that he has conflict of laws to struggle with. You filed a petition in the Lagos State High Court for nullity of marriage, and you declare the nationality of your partner, of your husband or wife, to be Ghana. You declare his nationality and his domicile to be Ghana and Kenya, respectively. The judge should know that he has a conflict of law, a private international law issue in his hand. Okay? And how does he resolve the issue? What is the issue? The issue is which law will govern this? Do you understand? Which law will govern the relief that I've been asked to give? Can I declare this marriage a nullity? If I have to do so, under which law will I be able to declare it a nullity? Clearly, this will be a different case from the one where Mr. A, a Nigerian, sues Mr. B, a Nigerian. The marriage was celebrated in the Ikeja registry. Hello? Okay, I've been made host. Can you please mute yourself? Can you please mute yourself so that we can enjoy our class? So, the judge will realize immediately, and the counsel, when presenting the case, will realize immediately that he has a conflict of laws problem on his hand. And where does he find his law? I just told you that the source of law in this area is received English law. The source of law is received English law, which then means that all of the things you will read in Morris or Cheshire or any English text will be very relevant. They will be very, very relevant. Okay? So what do we gather from those texts? What do we gather from those texts as the position of English law? English law, English conflict of laws for purpose of choice of law distinguishes between form and capacity. Form and capacity. In other words, if you want to nullify the marriage on the alleged basis of non-compliance with form, the test, as we have told you before, will be lex loci celebrationis, law of the place of celebration or formalization of the marriage. So in the first example, where we said, in your petition, you said the marriage was done in Ghana. The judge and lawyer is warned that the only law I can apply to determine the formal invalidity of this marriage is not going to be Marriage Act of Nigeria. Is going to be whatever law governs formality in Ghana. Lex loci celebrationis, that is the meaning. Okay? On the other hand, if the ground upon which you want to nullify the marriage falls within those grounds that our family law regard as essential validity, in conflict of law, we call it capacity. If that is the ground upon which you want to nullify the marriage, the judge will immediately, following the tip of characterization, the judge will immediately know that it is the law of domicile. The law of domicile, is it of the husband or is it of both the husband and the wife? We will debate that later. We will look at authorities on that. Definitely we can't get to that point today. Okay? No matter how much I want to rush, I don't think I can get to that point today. So those are the two tests. Lex loci celebrationis, if the ground upon which you want to nullify the marriage that has a foreign element before our court is form. Lex domicili, here in Nigeria, if the ground upon which you want to nullify a marriage that has foreign element is capacity. Those are the twin tests. Those are the twin tests. Okay? So every marriage is said to be valid, contracted between persons whose domicile gave them capacity to enter into it, and celebrated according to the formal validity rules of the place where the marriage was done. Those are the twin tests for nullifying a marriage that has foreign element. Okay? In contrast, if it has no foreign element, you'll be looking entirely at Nigerian law. But you will not be looking at Nigerian law if it has a foreign element. And that is why elementarily you are able to prove that Fonseca and Passman Court did not understand the tax before it. If it understood the tax before it, it wouldn't have been looking at Nigerian internal laws to answer the question of whether the marriage between the man and the woman in the Fonseca and Passman case was right. Okay? So we are going to let's start now with form. The first thing is to understand what are the issues that we will normally treat as. Okay, no, before we go to that, we said the rule is lex loci celebrationis. That's what we said, isn't it? This lex loci celebrationis, which means that you must invariably apply the law of the place where the marriage was formalized or celebrated or done. Is it an absolute rule? Does it have an exception? Is it an absolute rule? Does it have an exception? Under the common law that we have received, the answer is it is a rule subject to exception, and you need to understand what the exceptions are. Okay? Under what exception will a court be willing to depart from the local celebrationis in order to validate or invalidate a marriage? That's what we are discussing now. Under what circumstances? The first exception known to English common law is the one we call when the use of local form is impossible. When the use of local form is impossible. How can that be so? What do you mean by impossibility? Impossibility may be physical impossibility, but impossibility is also impossibility when issues like religious belief and what have you will not make that possible. Okay? Issues like religious belief, and local laws that impose status on what you have done. Okay? So if, for example, two Christians wishing to contract a monogamous marriage in a Muslim country where you do not have the type of marriage registry that recognize monogamous marriage. And every marriage you do, you have to do under the form prescribed by that country, and the status of that marriage will be contrary to what you want to contract. So if the only marriage you could do in a Muslim territory is nikah, and by its implication, the husband in a nikah is permitted to take more wives. And that's not what you want. On the other hand, that territory does not have provision for people with different idea of what marriage should be or what consequence of marriage should be. The consequence of of a monogamous marriage is that neither the husband nor the wife during their life and without divorce can take either another man or another woman as their spouse. Okay? That's what you want to do, but there is no facility for that. If you say you want to comply with the form provided by that territory, then you would have entered into a potentially polygamous marriage, which is not your desire. So English common law accepts that in that circumstance, there is insuperable difficulty. The form to facilitate the type of marriage you want to do is not available. And so English law says not complying with the local form will not be relevant if the man and the woman will do what is known as a common law marriage. A common law marriage merely requires a declaration between the man and the woman that they will be man and wife till death do them apart. So neither the man or the woman will be able to, in the future, get the court to declare that marriage a nullity simply because they did it in that territory and they didn't go to the marriage facilities provided by that territory. Okay? So that is one exception. So the difficulty can be physical if they find themselves on a territory that even has no arrangement. If they find themselves in a territory that has arrangement, but the arrangement is not for the type of marriage they desire to do. So English common law says they will be taken as man and wife till death do them apart once they have declared so. And non-compliance with local form will not be relevant. Okay? So that is the first exception.
Excuse me, sir.
Yes?
Please, I don't really understand this part you just explained now.
What is difficult there? What is difficult to understand? Yes, what don't you understand now?
But from the beginning,
Two people want to do enter into a monogamous marriage. The usual pattern is either they go to a religious setting, a marriage registry, etc., etc. And the implication is they want to be man and wife till death do them apart. Okay? But they find themselves in a legal district, in a state that has no facilities for that. Okay? The state has no facilities for that. And deep in their mind, they want to be married. Okay? They go ahead, calling a few friends and declaring that this is what they want. Years after, one of them who is fed up with the relationship comes to Nigerian court and says he wants the marriage to be declared a nullity because the marriage was done in territory A, not according to the territory A's rule. Okay? If we were to follow Lex Loci Celebrationis correctly, the court will easily pronounce that there was no marriage because the court will easily say, for there to be a marriage in territory A, this is where you ought to go, and you ought to accept that this is the implication of the marriage. You ought to do this, you ought to do that. Okay? Suppose the requirement is that they should go before the Qadi or the Imam, and you should use, say Holy Quran to solemnize them, which is not what they desire. Okay? So they will be able to argue that yes, we did this marriage. Who is this person that wants us to dance to his music?
Flight student Ngozi, please mute your mic.
Blessing Ngozi, please mute. We're disturbing the class.
Bless
Sorry, Blessing Ngozi,
my
please mute your mic.
So in that type of situation, they would be able to argue for the exception. That yes, the reason why we couldn't do so is that there is no facility in the place for the type of marriage we want. Okay? And the English court, upon having evidence that they truly declared intention to be man and wife till death or divorce do them part, would accept truly that they are married. Okay? Is it clear? Hello, the person who asked the question. Are you
yes, sir, I
satisfied now?
understand now. Yes, sir. Thank you.
Then the other exemptions include common law, English law permits marriages in countries under belligerent occupation to be valid even when it has not complied with the form prescribed in those countries. Okay? Here, we have a number of marriages that we are done in countries whose local laws prescribe that the solemnizing minister must have a license. Okay? So if you marry in the church, that does not make your marriage an act marriage unless the officiating minister has a license to solemnize marriages between two persons who wanted to do an act marriage. But we have a number of cases, including the one they call Taxanoska and Taxanoski. Okay? These were marriages that were done in territories where that is the rule. The rule is that you have to go to a church where the officiating minister is empowered by license to do so. But they didn't comply with that requirement. They did not comply with that requirement. And so when you are using Lex Locis Celebrationis, it is possible for one of the spouse to say, well, we didn't comply with form. We just went to one local church and the officiating minister said we were married. But the officiating minister himself did not meet the requirement of the local law because he didn't have the license to solemnize us. So for that reason, one of the spouses is arguing that the marriage was a nullity on ground of non-compliance with form. Okay? The English courts have been ready to say that because that country was under belligerent occupation, okay? Many countries were considered to be under belligerent occupation during the Second World War, okay? Taxanoska and Taxanoski, the Roman Catholic priest serving as a Polish army chaplain was not quite qualified under Italian law, not having been licensed. Okay? And the marriage was between one of the spouse was a member of the armed forces. So the question was, given that the marriage was celebrated in Italy and Italian law was not complied with, shouldn't the marriage be nullified on the ground of form? And the court answered, Italy was under belligerent occupation. Okay? So which makes belligerent occupation another exception to the rule. Although the decision has been heavily criticized, okay, one of the major criticisms there is that neither of the couple was even domiciled in England. So what was the English conflict of law zone? What was their concern? To help them validate their marriage. Okay? But the important thing for us is that English cases accept that if the marriage was done in breach of the law of a belligerent territory, a territory under belligerent occupation, then non-compliance with the form prescribed by that territory will not, if well explained, will not be a basis to nullify the marriage. Then again, there's a statute, the Foreign Marriage Act 1892. Foreign Marriage Act 1892, being an 1892 legislation, it will qualify as a SOGA in Nigeria. But I believe that we have similar provision in our law. Find out what is the similar provision in our law. Okay? So that statute provides that if the marriage is between members of the British Armed Forces and so if members of the British Armed Forces are serving in a foreign country, okay, it will be sufficient if a chaplain of either the Navy or the Army or the Air Force, okay, was the one that solemnized the marriage. It will not matter whether such persons were qualified under the law of the. You see that it is difficult to differentiate between exception 2 and exception 3. They are all based on the same basis. The same basis that it was duty that called and family could not be postponed. Okay? And so if you cannot meet the requirement, okay? Again, Section 8 of the Foreign Marriage Act of England, we have equivalent in Nigeria. Look for it. Validates of marriage, okay? One of them is if the marriage was done in the consular office of Nigeria, okay? If it was done in the consular office of Nigeria in a foreign country. So two Nigerians wishing to marry according to Nigerian law can go to any of our consular posts abroad and marry there. For all intent and purpose, they will not need to meet the requirement of the country where the consular post was established. It will be sufficient that they were solemnized by the marriage officer in the consular office of Nigeria abroad. That's just one of the many grounds that Section 8 of the Foreign Marriage Act 1892 sets out. Okay? Those are the exceptions. So, lex locis celebrationis as exception. And those are the exceptions we have mentioned. Okay? Now, lex locis celebrationis is talking about form. If you want to nullify a marriage on the ground of form, lex locis celebrationis. What are the issues falling under form?
Sir, please, the Foreign Marriage Act, is it a third exception?
Is it what?
Is it like a third exception or is under belligerent occupation?
No. It's a separate exception of his own now. It's a separate exception of his own. Under the Foreign Marriage Act, you will not need to comply with a local form if you celebrate your marriage in your country's marriage, if your marriage was solemnized by the marriage officer in your country's consulate. So you go to where your country's consular office is, go before the marriage officer there. He will ensure that you have complied with their own rules. That is your country's own rules for marriage. And subsequently, the other spouse will not be able to nullify the marriage on the ground that you did it in another country and you didn't comply with the law of that other country. This has been sometimes used by lawyers to say that that marriage is ipso facto a marriage that you have done in your country. But the English court rejected that argument in the case of Read 1 and Read 1. The fact that the marriage is validated under the Foreign Marriage Act does not mean that we are treating the marriage for all intents and purposes as having been done in your country. That is, in the country that established the consular post. Okay? So you have an English case where that became an issue. We normally discuss it under diplomatic and consular law. The case is the case of Read 1 and Read 1. Okay? So the important thing is that, yes, we know that you are not marrying in your country, but the Foreign Marriage Act says that anything regarding form, as prescribed by the country in which you marry, will not be relevant when once you are able to show that you have done the marriage before the marriage officer in your country's consular office. So those are the exceptions. I think time is gone. On Tuesday, we will continue by looking at what are the issues that fall under form. What are the issues that fall under form? Because you need to understand them as an expert or a judge. You read what the petitioner is saying is the basis that he wants the marriage to be notified. And once you understand the issues that come under form and the issues that come under capacity, you immediately pick that this is a matter for which I will apply lex locis celebrationis, or this is a matter for which I will apply lex domiciliis. So I see you on Tuesday, please.
Thank you, sir. Thank you.